Good afternoon, everyone, and welcome to the webinar, Bringing the Victim's Voice into the Courtroom. Today's program is presented by Equitas. My name is Mary McLeod, and I'm an Associate Attorney Advisor at Equitas, and I will be moderating today's webinar. Before this webinar, you should have received a link to a pre and post test. Please use the same anonymous, unique identifier you chose when taking the pre-test when completing the post test. If you have a question during the presentation, please enter it in the chat box to your right. We will answer questions at the end of the webinar. You are also welcome to contact us directly at any time following today's presentation, and we will send you our contact information during the follow-up. Equitas's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. As a national training and technical assistance provider, Equitas develops resources, conducts trainings, and offers 24/7 consultations for prosecutors and allied professionals. For more information on Equitas, please visit our website at equitasresource.org. You can also follow Equitas on Twitter, Facebook, Instagram, and LinkedIn. The link to each is available on our website. Today's webinar is supported by the U.S. Department of Justice, Bureau of Justice Assistance. The information presented in this webinar does not necessarily reflect the views of the BJA. Presenting our webinar today is attorney advisor, John Kurland. Before joining Equitas, John Kurland worked for 16 years as a prosecutor in the District Attorney's Office in Berks County, Pennsylvania, serving as Chief Deputy District Attorney, Chief of Trials, and Assistant District Attorney. Throughout his career, John has successfully prosecuted a variety of offenses, including domestic violence homicides, campus sexual assaults, cold case sexual assaults, intimate partner violence, stalking, child pornography and exploitation, child abuse and molestation, and human trafficking. I will now turn it over to John.
Mary, thank you for that introduction. And I also want to thank St. Paul for giving us the opportunity to present this training today as part of the St. Paul's IPS Innovative Prosecution Solutions Project. I especially want to thank Tara Patet for coordinating with us so well and being such a great liaison on this project and thinking up of the idea for this training series. This is part one. I don't have the calendar in front of me, but I know part two is next week. Part three is September 29th, and I think our final is on October. What I'm going to ask folks to do before I sort of lay out what our objectives are for this presentation, we do have some opportunities for participation during today's presentation, and you're welcome to do so either through chat or through the microphone or the audio. That's why we set this up in Zoom meetings rather than Zoom webinar. I would ask you though, when you're not actively speaking, make sure that your mic is off or you're muted just so we don't pick up any ambient noise. Also, in recognition that we have sort of a smaller group here that is going to be present for this training, if you're in an environment where you can do so, you have a connection speed that allows you to do so, I'd ask you to turn on your video, just because this, I think, makes it a little bit more personal. People are able to interact a little bit better. But if you're not comfortable doing that, that's fine, and I understand. All right, so let's kick this off. What are we going to be talking about today during today's presentation? Well, broadly speaking, as you can tell by the title, our goal is to talk about bringing the victim's voice into the courtroom. And this is anticipating those instances of domestic violence, intimate partner violence cases where the victim is unable to participate. They're unable to participate by testifying. They're mitigating or minimizing what occurred to them, or they're recanting altogether. And a lot of that discussion is just taking a deeper dive into some of the applicable toolbox of hearsay exceptions we want to use and trying to understand some of the legal challenges in using those tools. But to set the foundation for that discussion, we want to figure out ways we can help understand some of the reasons victims aren't able to participate in our domestic violence prosecutions and investigations. And we want to talk about ways that we can minimize or hopefully better facilitate victims being able to testify as full participants, and talk about methods and strategies we can use to strengthen their opportunity to participate. We also want to dive into, though, when even despite our best effort, victims can't participate, we want to talk about ways that we have the option or the ability to push our cases forward and hold our offenders accountable in ways that aren't dependent on victim participation. And so we want to talk about some methods we can use to work with our investigators and our allies in law enforcement. And when I speak of allies in law enforcement, I'm sort of approaching it from prosecutorial perspective, which I still consider myself where I come from, my origin story. But we want to talk about ways we can build stronger evidence-based cases that can allow our cases to go forward, even if the victims are not able to participate. We also want to talk about in those instances where the victim is not unavailable, but is minimizing the abuse that occurred or recanting the abuse that occurred, some trial strategies that we can use to have effective direct or what's effectively cross-examination of victims who are testifying, and a way to do that that can sort of meet our goals of showing the power dynamic that these offenders exert over their victims. So let's kick off right away with an open-ended discussion. And I'm going to ask folks to participate either via the chat window or through your microphone. And that is this, and it's a really broad, open-ended question. As prosecutors, as advocates, as law enforcement, wherever the disciplinary background of our audience here today, can you talk a little bit on a broad level? What are your goals in domestic violence cases? And I'm asking you to take a step back and sort of take a big picture that we can maybe sometimes lose perspective of when we're navigating the challenges of the cases that are right in front of us. When you signed up for this job and this gig, what did you hope to have accomplished or idealize as a goal in a domestic violence case? Or at the end of the day, even now, what do you consider a success when you're working a domestic violence case?
I will start it off, Mike Seasley. My goal is to reduce or end domestic violence, and in a broader sense to prevent homicides and serious injuries to victims and their families.
Safety, and I'm not trying to put words in your mouth, but just sort of resetting a little bit. So build safety, keep your community safe, keep your victim and their family safe too. Is that a fair characterization?
Yes.
Okay. How about anyone else that either complements what was discussed or maybe a little different perspective? Okay, we have someone in the chat window. Protecting victims and especially children from learning that domestic violence is the norm. So trying to break that cycle and prevent that from happening, and some goals to do that. Victim safety going forward, children not exposed to more violence. That's, of course, probably one of the big motivating things. And I think that's an important highlights why it was seconded.
Offender accountability.
Offender accountability. That's one aspect too. Okay, well, I think a lot of folks are going to echo what was already said. And you recognize it. Our goals in going forward to do this is supporting victims, whatever that support looks like. And maybe we have a preconception of what support looks like. Hopefully, after today's presentation, we can maintain a broad perspective on what supporting the victim can look like, but also holding offenders accountable. Sometimes these goals, they're difficult to reconcile. And these can be some of the challenges in going forward. Now, we talked about what we expect from domestic violence cases. For a lot of folks who talk about victim needs and victim perspective, let me reframe the question and ask everyone here, what do you think? We talked about what we want from domestic violence cases, what our goals are. What do you think victims want? What do you think they want when they contact 911 or when they initially talk to the responding police officer, what do you hear are the primary complaints of the victims about the domestic violence? Can folks share?
I would say the same thing, that they want the violence to stop immediately.
They want the violence to stop. They want safety. That coincides with us. How about anyone else? Anyone want to add to what Mike, right? What Mike said?
Yes.
I'm Allison. Oh, go ahead, Ricky.
Thanks, Allison. I was just going to say my name is Ricky Rodriguez. One of the most common things I hear victims say on 911 calls is they just want him out of the house, or they just want the person gone. So.
Thank you, Ricky.
I was going to say, this is Allison Fredrickson, that, you know, chemical health help or anger management, some kind of programming, so that if they do remain in a relationship, that person gets help.
So, thank you so much for sharing. So some of these goals overlap with what we were talking about earlier as to what we're hoping to see. Some of them don't necessarily overlap. They may not always directly conflict, but especially when sometimes we want to hold the offender accountable, that might not be the victim's priority. A victim might want safety, stability, treatment. Basically, they want the adverse circumstance to stop, and as best they can in their circumstance, within the context of their whole life, they're trying to imagine and how they accomplish that. Usually, and I think if folks disagree, please let me know. When a victim reaches out and calls 911 and has that response, that's usually not the first resort of a victim. A lot of domestic violence victims, and from what I hear, it's usually going to be one of the last resorts. And it's because other solutions or other options haven't worked. And so this isn't the criminal justice system is usually not going to be the first option for most victims. And I bring that into the conversation, not to criticize or anything like that, but just to hopefully understand that perspective. So what I want to do now is, after the short conversation we've had so far, I want to present a video about a victim's decision to participate in a domestic violence case. And this is about a 3-4 minute video, and just it's played out by actors, but some of the issues I think you'll find familiar and things you've heard about in maybe your own cases. And I want you to listen to it a little bit, and then we're going to have a conversation or discussion afterwards. So ideally, I have my share audio on. If I don't, we'll find out shortly.
All right, your turn, Portia. Come on, guys.
Mom, can we play till I win?
Audrey, it's been so crazy around here.
Girl, what did he do now?
Girl, I did it. I called the police on his ass and they took him out of here.
Oh my goodness. Mom, I got into the band. Miss Peters said I'm good enough to play the violin.
Mommy is so proud of you. I just want you to know that I knew you could do it.
Hey, what do you think we should do for Mom's birthday? How about a surprise party? That'd be a great one.
Mom, when is Dad coming back? I hope he's here for Christmas.
Daryl, are you ready to go?
Baby, you know I didn't mean to do that. You know how much you and the kids mean to me. What can I do to make
No. Calvin, I've heard it too many times before.
Mom, those people are at the door again.
All right, just tell them I'll be down there. Just go downstairs and wait. I'm on my way.
What did you do? Why these people tell me I can't see my kids? Oh, you're gonna pay for this. Rachel, you listening to me?
Mom, can I have a friend over tomorrow?
Portia, I don't know, okay?
But Mom,
I'm very busy.
Dara got to have a friend over last week.
Ms. Williams, I'm calling to inform you that you're past due on your phone bill. Would you be able to make a payment by the 30th?
I don't know. I really don't know. Hey. Don't cry. Hush. Listen, those kids don't know anything about you. You are a wonderful child. You are a beautiful girl.
Hey, Mom, Pastor Foy called. He wants to know if we can sing at church. I told him we will.
But Daryl, oh.
Mom, don't forget I have basketball practice after school.
I won't forget, Portia. I would never forget. When is it?
Mom, I don't feel good.
You don't feel good like what?
Don't hang up. Just let me tell you. Hey, the last time I talked to you, I was just really upset. Just, let's just work this thing out.
Calvin, no, it doesn't work like that, okay? Audrey, I do not know what I'm going to do. Girl, they are evicting me. I mean, I won't have a place to live. Girl, what am I supposed to tell my kids?
I know y'all miss me, right? Is Mom taking good care of y'all? Now, I'm gonna be home as soon as I can, but it's up to your mom.
Mom, when is Dad coming home?
I don't think Dad will be coming back home, honey.
He wants to come home, but he says he won't let him.
Oh, baby.
Mom, I aced my spelling test. Can we go shopping? Mom, can you tell Dare to get out of my space? She started it. Did not. Did too.
Stop it!
Okay, so let's have a little conversation around this piece. Folks, you were talking about before we shared that little vignette that talked about really sort of focus goals that in your experiences victims have, or focused expectations about what they want to have accomplished when they reach out for 911 or kick off or initiate something with the criminal justice system. Let me ask you from that, and even if in your cases, maybe you don't have all that cascade of consequences that happened to your particular victims, but listening to that, what were some of the, compared to what in your experience might be sort of focused expectations, what were some of the collateral consequences when Rachel called the police that day? What happened to her life? And I guess then the follow-up question that flows right from that is, do you think she expected that to happen?
So even though it might be an abusive situation, there's support that he lends to the relationship, maybe financially, maybe with looking after the children, and a bunch of other things, that because he's not there, that support is no longer there for her. And so that's one of the collateral consequences, I think, is that she just doesn't have the support that he provides, notwithstanding the fact that he's possibly an abusive person.
So yeah, if one of her goals was stability, there's certainly less family stability as a consequence of calling the police. What about other aspects or other consequences? Can folks identify that? Or any?
Well, his comments to the kids was really pitting Mom against him, which really sucks.
Yeah, well stated.
That's a term of art.
So I remember that from, I forget some statutory definition about sucks. But yeah, that you've articulated it. And so not only is she being victimized, but the kids are they're not getting closer to her. They're being more isolated. What about any sort of legal, economic consequences to that, to her life as a result of calling the police?
And to go off of what Dave said, Child Protection Services is now involved, and they're going to have this, legal battle over the kids.
So her life's in a microscope, and again, being a sole caregiver or single parent, it can be challenging in non-abusive situations, and certainly the challenges are amplified. Now, the reason we introduce this video, or we sometimes use this video as a teaching tool, is to express the idea that a lot of times, and I know as folks who work in the system, and you might get a little seasoned and maybe even a little cynical to some degree, although I'm sure everyone tries to guard against that, But victims who don't want to participate, I know it can be frustrating, it can be challenging. Maybe sometimes the victims are even adversarial with us about their desire not to participate. But we want to sort of get an appreciation for some of these challenges victims have in participating in the system, and at least some empathy or understanding for some of the challenges or barriers that they do have in participating, so that we can at least understand that about what's happening with them. And that's the other reason too, in terms of terminology, I sort of like how the video leaves off on the note, victim refused to cooperate. One of the things that I'm always careful to do, and I'd recommend, I never sort of frame it in terms of the victim cooperating or not cooperating, because it suggests almost a willfulness on their part rather than just being boxed in out of options, but frame it in terms of participation and their ability to participate, whether they want to participate or can participate, just because that's more victim-centered than a victim cooperating or not cooperating. Folks, any idea, and I'm not saying there's an easy answer to this, but listening to Rachel's circumstances, anything you think the system could do to make it easier for her to have participated, anything you do in your system or in your community to sort of mitigate or minimize some of these challenges that a victim like Rachel might face when she reports abuse? And these aren't the easy answers. So, and I think it's certainly okay if you don't have answers, but getting an appreciation of these challenges, I think is the first development to try and sort of think of methods that they can be mitigated. And that's ultimately what we want to talk about, and why we sort of talk or use the Rachel video as a teaching tool, is because we want to understand the barriers victims face. They're going to face barriers that are going to be created by the offender, by the batterer. They're going to have systemic, and the combination correlation of all these barriers are going to be victims who are less willing to participate. I often think with intimate partner violence cases, it's not surprising that victims don't participate. It's surprising when you have any victims who do participate, given the sort of, not just the adversity of dealing with the system in of itself, but all the sort of collateral consequences. And also to gain an appreciation about, is for folks who are prosecutors in this audience, and I see a lot of the IDs with the St. Paul City Attorney's Office, so I know there's more than one prosecutor in the office or in the audience today. But understand that as prosecutors, if in our goals to be victim-centered and offender-focused, part of how we do that is that we want to try to, as much as possible, to have a role in breaking down these barriers. And yes, it's the victim-centered thing to do, it's the empathetic thing to do, but even if we do have a primary focus on holding these offenders accountable, by looking for ways we can facilitate a victim's participation, we're going to be more able to, or better positioned to, hold an offender accountable, because the victim's going to be more likely to participate. So it's really, if our responsibility is wider than just presenting testimony in court and checking off the elements for whatever crime we've charged, and not just viewing our victims as maybe talking exhibits, but recognizing that this case that's just one on our desk, for the victim, this is impacting their entire life, and sometimes the most intimate parts and most pervasive parts of their life too. But we also want to recognize too that victims participating and their safety may be mutually exclusive. And what do we mean by that? Sometimes victims understand that there's not going to be a lot the system can do to protect them. And victims might understand the best methods that work for them to minimize or mitigate the offender's ability to abuse them, and they might put those actions into play. So you might get frustrated. You hear a victim contacting the offender in prison while they're in jail, talking to them, exchanging details about what's occurring in their daily life, and you're like, oh my gosh, why is the victim doing that? The defense attorney is going to hear this and think the victim's not afraid of them. for many victims, they understand either on a conscious or maybe even an intuitive level that this for them is the best way to manage the offender. That if they don't do this, the offender's not just going to give up and leave the victim alone, but the offender might engage in methods that the victim isn't aware of or would be surprised by. And so a lot of things the victim is going to do, including continuing contact with the offender, is a lot of times the judgment of victims making is the best way they can manage and maximize their safety in what's an awful situation. And so when we're dealing with victims who have behaviors that might seem challenging for us and difficult to understand, appreciate that as much as the offender understands and knows the victim also knows the offender and what's going to key off the offender and what's going to prompt the offender. So we talked about barriers a victim has in participating. Let me also ask you about just, and I think we had some good examples with Calvin there, and I think Mike alluded to them. How do offenders negatively impact our ability to prosecute intimate partner violence? And these challenges we sometimes have from victims in going forward or victims participating, sort of reframing that, how do the offenders cause these challenges or are responsible for those challenges? Can folks share from your experiences or what you see in your cases, what offenders are doing that make these cases harder to prosecute?
Manipulating the victim.
What are some ways you've seen offenders manipulate the victim, Tara?
Everything from an apology to working through the kids to doing things so that she's more dependent on him financially to, I mean, just a whole variety of things that don't go as far as outright intimidation, but are more manipulate her to make decisions that are probably compromising her safety, but make sense to her at the time.
Thank you. And you sort of hit on some of the common issues, like, of course, kids being used as a tool or device, economic dependency. And again, we're looking, and sometimes when we come into a domestic violence case, it's in response to a single specific incident. We don't always get the context of the before or after. We don't get the context of what's the process of grooming or evolution about how the offender got the victim so economically dependent on them. So the victim was in this situation. We don't maybe understand the victim's sort of stripping away of a support system, maybe the things the offender has done gradually and subtly over a period of time to isolate the victim. So there's really no place the victim can go, and it's pretty easy for offenders to gaslight the victim and sort of just confront with the reality you think there isn't happening. And we don't get to see that because, again, victims are reaching out to 911 or the police, not as a first resort, but as a last resort or later resort. So yeah, offenders might use sort of the traditional stereotype we're thinking to control victims, fear. Like, if you don't do this, this abuse is going to happen, but it can also be fear through, hey, there's going to be economic consequences. There's going to be custody consequences. There's going to be maybe societal costs. Maybe people at church or in the community are going to look at us funny if they think I'm an abuser, or if you're being abused and that you lived with this and that you suffered it, or that you sent me to jail. The kid's still going to see my family, and what is the family going to think you did? And this overlaps, of course, with manipulation. And a lot of times too, victims that we're interacting with, when we interact with them, that's the product of a cycle of domestic violence. And so there's going to be prior traumatization that's going to be in play too, and also that's caused by the offender and perpetrated by the offender. So of course, and we're familiar with the product of all these offenders' actions and how they can result in frustrations and challenges in prosecuting domestic violence cases. We can have, of course, victims recanting or minimizing challenges in finding our victims. We can't locate them. Victims showing up and testifying on the defendant's half, victim returning or staying with the offender, maybe as a way just to manage their own safety, maybe because they don't have any other option or any other support network, or victims engaging in unlikable behavior, and including if folks here have had any victims be adversarial with you or curse you out or be really upset with you, even when you think you didn't deserve it, and you probably didn't deserve it, raise your hand. If that's never happened to you, let me know, and I'd be curious. Okay, I don't see anyone coming forth saying that's an alien experience, so I'm going to assume that's normalized. But all these are issues in the case, and these are things that we need to explain, or the jury or our judge isn't going to understand. And so these are things we have to explain and try to put into context. It's going to be a lot more difficult to put in context if we only approach our domestic violence case with just a narrow focus or spotlight or lens on the incident that prompted the response, and we don't take a more expansive look. But also, to try and mitigate these barriers to participation, we want to be holistic in meeting the victim's needs. And that's more than just giving them notice of court hearings and meeting with them, but as much as possible, trying to provide for their safety. And part of providing for their safety means listening to them and listening to the victims about how they know what their safety concerns are and what their safety plan is, even if they don't articulate it in those terms. On the legal end, we can do the minimum, such as trying to argue for protection orders, no contact orders, not being quick to acquiesce into the offender being able to have third-party contact with kids or contact with the children, recognize that they can often be vehicles of manipulation or intimidation that offenders use. We want to keep our victims informed, even when they're engaging in unlikable behavior. This means include them in the decision-making, tell them what we're doing about the case. Don't try to make any secret sauce, but keep them informed about what they're doing. Even if we think they might be someone who's minimizing or recanting or might show up with the defendant, always give them respect as an individual and recognition of their autonomy. Try to protect the victim's privacy. Privacy a lot of times is going to be like oxygen for cases in intimate partner violence. We want to do motions ahead of time that prevents maybe the defense from trying to bring in ancillary issues that are primarily motivated to embarrass a victim into not participating, by litigating and trying to prevent these through pretrial motions in limine and hearings, or redacting information when we can suitably do so pursuant to the rules of discovery. And also timeliness. And this has got to be incredibly challenging in the context of courts that are being shaped and impacted by the pandemic. Because I know with backlogs, every case is on an extended timeline. But as much as possible, we want to try to keep the machinery moving, but also be realistic in our conversations with the victim about what sort of timelines they can have in this case, even when it's an I don't know. Talk to the victims openly and candidly about why we don't know. And insofar as possible, opposing motions for continuance when we can do so in good faith, or when we think those motions for continuance are primarily motivated just to wear down a victim. So this isn't something as prosecutors we have to do alone. There are tools that can assist us in giving this kind of support for the victim. Certainly by working with advocacy services, whether it's system-based advocacy or whether it's going to be community-based advocates. And I know in St. Paul, you have good multidisciplinary relationships, and that's an asset worth leveraging so that it can be almost a force multiplier for what you're doing as law enforcement or what you're doing as prosecutors. Trying to get danger assessments. And usually I think the great asset, the great utility of danger assessments is ultimately the ideal for any kind of domestic violence case, is that we could almost approach it as extensively and as holistically as we would a homicide case. Now, maybe in terms of capacity, that's not realistic to do with every domestic violence response because it's not just a one and done effort. but danger assessments and lethality assessments can be a great tool to triage which domestic violence cases we do need to put that sort of more extensive effort, both investigative and as prosecutors, into. So before we get into how we're going to bring in the victim's voice, we do want to give a little context about building an evidence-based case. And building the evidence-based case is terminology that I never liked. I didn't like it as a prosecutor, and I don't like it as an attorney advisor with Equitas, because my thinking would always be, well, wait, evidence-based case, that's not terminology that makes any sense, because as a prosecutor, all our cases are based on evidence. Nevertheless, this is the terminology that we utilize when we talk about, especially in intimate partner violence cases and domestic violence cases, about building and presenting a case in which prosecutors can hold offenders accountable with or without the victim's testimony. So it's building our case from the ground up, from the foundation, and from working with our first responders and responding officers and law enforcement investigators about how we can build a prosecution that doesn't rely or anticipate the victim testifying or being able to participate. This is something we do regularly in homicides where a victim can't testify. We still prosecute murder cases and homicide cases because we learn how to build cases. So the tools are always there, but it's not an easy thing, and it's not something that necessarily requires a light touch, because what these require is ultimately evidence, and collecting evidence as extensively and as expansively as possible. Now, there isn't any circumstance in any kind of case, and I don't care what it is, where every potential piece of evidence can be collected. But the more that we can do, the more that we can catalog, the more that we can gather, the greater our potentiality for success. So in terms of domestic violence cases, what we're ultimately looking to prove or show or build evidence or a record of beyond the victim is ways that we can not just establish the elements of whatever offenses we've charged, but also show the context of the domestic violence or intimate partner relationship, the context about what happened prior to this episode of domestic violence that initiated law enforcement response. And we also want to be looking to build a case that's going to be able to explore, anticipate defenses, and more often than not, be able to minimize or rebut defenses. So the kinds of categories, of course, in any domestic violence case, we want to be able to have evidence independent of the victim of the injury. How we're going to show attempts to cause bodily harm or attempts to cause bodily harm. Obviously, photographs are going to be one area, but it doesn't have to be exhaustive. It can be third-party witnesses. Statements the victims made. And this is usually going to be the most critical, because usually the account of what occurred is going to be the victim. Without the victim testifying, we want to be able to identify those statements that we're going to be able to get in, that if the defendant isn't testifying, if the victim isn't testifying at all, or that can be brought in circumstances where the victim is minimizing or recanting, or if the victim is participating, that can corroborate what the victim is saying. We're going to be wanting to show the crime scene. And this is true in any kind of case. Ideally, it's going to be as much as possible, maybe even processing the crime scene, maybe even having scaled diagrams and evidence tents and things of that nature. That kind of capacity or commitment may not always be possible or may not always be available. Hopefully, at a minimum, though, we're having some photographs of the crime scene itself. We're having responding officers that are going to be taking photographs of the exterior of the location that occurred, the interior where the assault or where the abuse occurred, the people that are on the scene and that are there, maybe even a diagram or map of the area where it occurred, just to give that sort of visual reference or cue to a jury. So often people think visually today, or they understand visually more than narratively. The more we can give visual tools and exhibits that can help a juror or fact finder visualize, the easier it can be for that juror to ultimately understand the evidence. Sometimes the easier it might be also for witnesses to testify and to talk about what they see from a picture or what they remember or can observe from a picture. Trying to capture the demeanor of not just our victim, but also our offender involved. Usually after the fact, you're going to have offenders that are going to be minimizing, that are going to be painting the victim as crazy, as things like that. A lot of times when we capture the evidence fresh from the response, we can show almost sort of the callousness or indifference that offenders have, and just the sort of kinetic excitement that victims have that show the traumatization that occurred. We also want to be building as much as possible the prior history of the relationship. Now, sometimes this is more challenging to get in when the victim isn't participating, but we're building our case in anticipation of whether or not the victim participates. So we always want to try to be finding the prior history because, one, as we're going to be talking about next week, it might make it easier for when we need to show indications of witness intimidation, but it can also help us with more charging decisions too. So I have a quote here from the Duluth Police Domestic Abuse Policy, and this is something we regularly use. Using it in a presentation with St. Paul, I certainly hope I'm not activating any insipid rivalries that may exist between St. Paul and Duluth. That can be some of the challenges in national training. I can miss these statewide rivalries, but Duluth has a good policy, and it's one I recommend. And it recognizes, of course, that a lot of the foundation for a successful evidence-based prosecution, it's ultimately going to be heavily dependent on the extensiveness of that initial response and that initial investigation. And this is a great policy from Duluth Police because it recognizes that. And you can see that in the highlighted portion of the policy. The investigation of these cases sets the foundation for almost every subsequent action by the courts and community-based agencies. It's the cornerstone of an effective, coordinated interagency response. And by recognizing that, I'm not trying to minimize the role of prosecutors, because ultimately that when we have law enforcement agencies that give us this really expansive and extensive initial investigation, that's great. There's going to be more work for us as prosecutors to do, but we need to have those tools or those resources, those ingredients available. To the degree that maybe we're upset or we're not confident that we're getting as extensive investigations as possible from our partners in law enforcement, then one of the things we want to do is interdisciplinary partners is then talk to our law enforcement friends and talk about ways and educate them about ways like, oh, gee, if this is available investigations, these are the options it can give me as a prosecutor, or the other options I can have to do this, that even if the victim isn't participating. So if this isn't done in law enforcement, I don't want to put all that burden on them, because it's up to us as prosecutors to be having those conversations with them. And this isn't true on just a system-based level. I think this is true on line prosecutors and responding police officers and patrol officers, to have these conversations with individual cases, where if you as a prosecutor think, oh, gee, I wish I had this, talking to your police officer about, oh, gee, why you wish you had that. Or when you're asking your police officer, did you do this? Did you do that? Not doing it sort of confrontationally, like, oh, did you do your job? But explaining why or what that would allow you to do. So even if that evidence or wasn't done in the case you're talking about, maybe you're planting a seed where you're giving that officer the idea to do it in a future or subsequent case. So ideally, with these investigations, what does this holistic investigation include? Well, it's hard to encapsulate other than with the word everything possible. But at a minimum, it's going to mean photographing or video recording crime scenes. Hopefully, this is a little bit easier to do with body-worn cameras. Especially with being able, with the second and third bullets here, documenting the demeanor, not just of the victim or the suspect, but also of third-party witnesses. So that can be a great way to memorialize and preserve statements in a way that we can utilize later for court. Ideally, if body worn cameras are the only way to record the crime scene. That's better than not recording the crime scene. Hopefully we're actually taking independent photos of it that don't depend on trying to grab screenshots from a body camera or the jerky sort of vertigo inducing review of that footage. Ideally with a cell phone, better yet with an actual digital camera. Hopefully the investigations are also involving in interviewing more than just the suspect and the victim about what happened, but also witnesses to not only to the crime, but also the history of the relationship. This can be family members, these can be neighbors, these can be coworkers, this can be part of the social network of both the victim and the offender, especially when they overlap. Not just investigating the offender actions of what happened at the time of the assault, but also keeping track and watching what the offender does both prior to the incident and after the incident. Because again, this is an offender who has a relationship with the victim. And so even with usually with no contact orders, the offender is not just going to not worry about it after the police respond to the incident. The offender is going to be actively trying to maintain a relationship with the victim, either through themselves or through third parties. So these are things we actively want to investigate. And also being able to conduct digital investigations into things such as electronic devices and social media and things like that. Part of protecting privacy and our victims' privacy and being alert to ways to do that, we want to be careful with the victim's digital privacy and try to protect that during our investigations as much as possible by doing things like, instead of, when we can, just taking screenshots of maybe relevant text threads or communications rather than actually seizing the device. That's not always possible with victims. With offenders, we probably are looking for ways we can seize a device and conduct as extensive a search as we can legally do. Here's another sort of synopsis or summary of the sort of evidence collection we want to do. Of course, any recordings of a 911 call, statements, cataloging and investigation of the crime scene. We want to be having the children interviewed at the scene too, and get statements from the children that are at the scene. Now, taking statements from the children doesn't commit us to calling the children as witnesses later on. And I'm not trying to suggest that calling the child in a domestic violence case is the solution in every case, because sometimes it can expose the kids or the children to safety issues from the offender. But we hopefully want to be able to interview them at least to get their statements and explore that as a possibility, potentially maybe even arranging for to get a forensic interview of the child with a qualified forensic interview, especially if you have resources like a children's advocacy center or other resources available, just to get those sort of statements from the kids. By not interviewing kids at the first opportunity or at that initial response, it doesn't commit us to calling the kids as witnesses later on, but it certainly, if we don't do it, it limits our options of exploring that with the kid when appropriate. Sometimes the kid might want to do so because they want the violence to stop. Photographs, which are especially easy to do. Now, I came on and started doing this stuff in the 90s, where every photo had to be strategically calculated about whether or not to take, because it had to be developed and there would be film and copies. With digital media, photos of crime scenes, it's a lot easier to do, even if there's a lot more to review. But we want to be taking photos, not just of the obvious injuries, but also any absence of injuries. And recognizing too, that when we're taking photos of injuries, they might not always appear right away, but we want to be setting up opportunities maybe for 24 or 40 hours later to take subsequent photos in case any injuries further develop, which can also be a good time to sort of connect with the victim when things are a little bit less harried, try to set up more extensive support services and get some victim-centered practices going too. Taking photos of the defendant, either especially any presence of defensive injuries or absence of injury. Also getting medical records, which is going to be a critical tool for part of what we want to be able to find admissible statements from the victim that we can be utilized even if the victim isn't participating. So medical help, and we want to talk to our law enforcement responders about this. medical assistance for the victim, it's victim-centered and critical to really always encourage, not only because there might be injuries the victim's not aware of, but really the offender-focused dynamic about why medical treatment is so critical is because a lot of times we're going to have statements we might be able to utilize from those medical records, which we'll talk about more deeply soon. And of course, any sort of evidence-based prosecution, it's not a one and done thing. It's going to be ongoing, ideally monitoring social media, keeping consistent contact with the victim and or their advocate, not just in response to when a hearing's coming up, but regular contact, building that relationship, following up with the social networks at all, keeping a monitor as actively as possible on visitor logs to the jail and phone calls. But also trying to identify and document non-testimonial statements by the victim. And this is really the segue to the title of what we're talking about, identifying admissible statements from the victim, especially when the victim isn't going to be participating in the prosecution. Now, ultimately, what we're trying to find is going to be non-hearsay and admissible hearsay type statements. Where can we find these statements, and where do we want to be talking about with our investigators about where to keep their antenna up for these statements, and where do we want to keep our antenna up about where we can find these statements to use when that victim's not returning our phone calls or responding to subpoenas, or we can't find our victim, or we see them walk in with the offender and the offender's attorney. Well, 911 calls is really going to be a prime candidate, but sometimes it's, of course, not always our victim that called 911. Sometimes it might be a third party like a neighbor. On-scene statements that the victim makes, certainly on-scene statements to law enforcement, but also any on-scene statements the victim might have made to third parties, such as neighbors or family that was present, children that were present at the scene. There could have been friends and family that the victim spoke to either before or after the incident about what happened. And again, also any statements the witness may have given to medical providers. And this could be medical providers at the hospital, such as nurses or physicians, especially if our victim went to an emergency room, but also paramedics and EMTs and people that maybe were there with the responding ambulance. People that were not medical providers that were not law enforcement related. So what we're going to be doing now is sort of diving into some of the specifics about what makes a statement admissible, and sort of giving an overview of confrontation rights, hearsay rules, and Crawford. I know for folks who may have been more recently graduated from law school, and at this point in my career, I consider recently graduated within the last 10 or 15 years. I never thought I'd be in that position. This might seem like a flashback to maybe evidence class, or maybe the sort of tools that you're confronting. And to the degree it's a reiteration of things you deal with in your daily practice, or sort of might be secondhand, I apologize, but we want to sort of break down with the fundamentals about sort of analyzing potential statements that can be utilized on a really sort of fundamental level under hearsay. And so we're going to begin with what for most lawyers was a mainstay of their evidence class in law school, a discussion about hearsay. And Minnesota codifies it under your Minnesota Rule of Evidence 801, which is consistent with the numbering of every other rule of evidence and the federal rules of evidence, and is modeled pretty consistently with that, if not identically. But hearsay, of course, is a statement other than one made by the declarant while testifying at the trial or hearing, and it's going to be offered in evidence to prove the truth of the matter asserted. Now, there's some words we want to identify, and that the rule also further defines and identifies. A declarant is someone who makes a statement. Minnesota's rule actually does that. Not all the rules in every other state actually do that. And it's pretty helpful for, I think, a layperson who picks up the Minnesota Rules of Evidence, and the word declarant might not be intuitive. I know I never heard the word declarant until law school. And a statement is an oral or written assertion, or it can be nonverbal conduct if it is intended as an assertion. Now, maybe this isn't the custom or tradition with Minnesota or St. Paul practice, I know sometimes after law school, there can be, in my experience, sometimes lazy analysis of hearsay. And anytime you hear someone say a statement and they're not in court or it's out of court, it's automatically sort of reflexively dismissed or characterized as hearsay. But really, what characterizes a hearsay statement is that assertion, the truth of the matter asserted, that someone is declaring something and that's why you're trying to get it in and the person isn't there for cross-examination. So we do have some exercises here to sort of clarify these concepts. And I'm not asking you to analyze whether or not this is admissible or not admissible, these examples. I'm just asking for sort of a consensus or view about whether this is or isn't hearsay. So hearsay or not hearsay. Officer reporting what a victim told them at the crime scene. Is that hearsay? How many people say, no, that's not hearsay? Chime in on chat. That we can get a better sort of consensus. How many people say it is hearsay? Indicate, let's take a vote in chat, what you say. Hearsay. So the boss has said it's hearsay. Who wants to be brave and take objection and say not hearsay? Yes. So depends. Okay. Hearsay unless exception present. Kyle had said that. Well, technically, I'm going to take. I'm going to quibble with Kyle's definition. If it's an exception, it's still hearsay, but then it might be admissible. So the issue is, and depends is a good answer, and that's always a safe legal response, as it depends. And I've resorted on that himself. But for the strict question about whether or not it's hearsay, it is. If the officer is saying, and assuming we're there for the assault case, and so that could be sort of critical what turns on the depend, is if we're there for the assault against the victim and the victims, and if the officer's there to talk about what the victim said about relative to the assault, then it's hearsay. If the officer is just saying to show like how sort of excited, then it might not be hearsay. So, and I'm sorry, I don't know the first name, so I'm just going to call you Akon. That is an actually pretty nuanced answer. And so, this, and especially in light of what Akon brought up, I think might be a little bit more direct example when you really think about it. Victim telling the court, not what happened, but the victim telling the court what she, and I'll just use she, what she told the officer at the scene. Is that hearsay? Again, we're not asking if it's admissible. We're just asking if that's hearsay. How many people say hearsay? How many people say not hearsay? Not hearsay, not hearsay. Okay. So I see a few votes. I see three votes right now for not hearsay. Let me ask you, Lionel, Ricky, or Akon, can you talk about why it's not hearsay? She's the declarant. Okay, because she's the declarant. Well, she is the declarant. She's not the declarant. She's the witness. Let's go back to this definition. Hearsay is a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. So you're right, because under this, it's other than one made by the declarant while testifying at the trial or hearing. I sort of read that as if the declarant's talking about what happened rather than what she said to someone at the time, then it probably technically is hearsay. I think it's probably going to be consistent, especially it's probably going to be admissible, especially if it's offered as a consistent or inconsistent statement for some reason like that. But it's so I think for it to not to be hearsay, as I understand that definition, if the victim was telling the court what happened, that's a statement, it's being asserted, but the victim telling the court what she told the officer at the scene, if that's being offered for what she told the officer, then that could be hearsay. That's how I read the definition. I don't know if folks have a different experience with that. But again, we're not trying to dive into whether it's admissible or not admissible. We're really just trying to unpack the nuances of hearsay or not hearsay. And again, it's something that doesn't always lend itself to sort of knee-jerk analysis. So we got two more examples. Victim testifying that she told the defendant she wanted to leave the relationship. Does anyone have a bright answer or a bright line answer on that, whether that is or isn't hearsay, or it depends, you need more information? So generally speaking, I think you're going to need more information because, again, if we're having a hearing where whether or not the relevant issue is if the victim wanted to leave the defendant, then that could be hearsay if she told the defendant that. Because if we don't really care about the truth about whether the victim did or did not want to leave the defendant, then it might not be hearsay. And it still might be relevant because it still might be relevant to show why the defendant wanted to hit her or abuse her or what the defendant's motivation was. So the content of the statement itself, who cares if that's true? It's not being offered as to say the victim really did or didn't want to leave. That's not something we can be agnostic on, whether that really was the victim's feeling, but how it impacted our defendant does depend on why that is or isn't hearsay. The last one, based on us just looking at the definition, this might not be too tricky. Friend of the victim testifying that the victim nodded yes or affirmatively when the friend asked, did the defendant do that in relation to some injury that's observed? And I think that example, it's sort of almost rhetorical because, again, even though there's nothing verbal that the declarant, the victim, gives in that, if it's coming from the friend, the nod is meant to be the truth of the matter asserted about the defendant actually having been the one to perpetrate that or do that. So Mike had pointed out about things that aren't hearsay, and these are prior statements with the witnesses. Now, the one is sort of characterization or breed of other prior statement by the witness that is probably never going to come up in a domestic violence case is the third one. Usually, if you've had a domestic violence case where the identity of the perpetrator was an issue, then I mean, I suppose that could happen, but that's not something we design this content around. But usually, in terms of what is or isn't hearsay in Minnesota is consistent with the federal rules where they, rather than characterizing these as exceptions to hearsay, they're characterized as just being non-hearsay. And that is an inconsistent statement with present testimony and denies prior statement having been made or forgotten. And of course, this is going to be the exception we're going to be utilizing when a victim is recanting or minimizing their prior testimony. The second one might also be coming up in our domestic violence prosecutions where the victim made a consistent statement with current testimony and it's offered to rebut an express or applied fabrication. Now, this exception, we're probably not going to be utilizing it as much when the victim isn't participating in a prosecution, but when we do have a participating victim in a domestic violence case, this might be something we want to be aware of. And of course, the trick with this is making sure that the prior consistent statement, that it came up before whenever the allegation or motive to fabricate arose, not after. It's not just that they made a statement prior, but that's consistent with testimony, but the statement was prior to whatever theory the defense or our adversary has adopted as the motivation to fabricate. And here's an example, and I think what can be one of the most relevant examples for domestic violence cases, and that might be with U visas. Maybe you have a victim who's undocumented, and the victim of domestic violence. And after they report the domestic violence, they begin the application for the U visa process. And the U visa is a special visa granted to victims of domestic violence. And even if you're undocumented, you can stay, you aren't going to be subject to deportation. It gives you permission to stay in the country. So defense counsel might say, well, gee, the only reason a victim who's undocumented might report domestic violence is so they can take advantage of this U visa program. And this usually gives a really great window for us to utilize this prior consistent statement theory, because most victims haven't learned about the U visa until after they reported the domestic violence. It's not something commonly known that most victims are going to have in their pocket. So an example of this sort of questioning is on redirect, the prosecutor might ask, defense counsel asked you about applying for a U visa. What you want to establish is when that U visa was learned about. And here's a sort of, maybe it doesn't develop this neatly and succinctly in redirect examination, but here's an example of where it could pass muster for a prior consistent statement. Where a victim would be saying, after I called the police and told them what happened, they connected me with an advocacy group and told me about U visas. Then you could bring in the prior consistent statement about what the victim had told the police about that abuse to corroborate that the testimony at trial is consistent with what was said before the motive to fabricate developed. Prior consistent statement, it might also play in if there's a custody issue or child support issue or alimony issue. Maybe the defense is saying these allegations of abuse are just being brought up for that. So if you can find disclosures the victims made before those areas arose as a concern, you have a tool you can use to corroborate your victim's testimony. But the other thing we're going to be relying on, especially for when victims aren't going to be participating, is of course exceptions to the hearsay rule that are usually pretty much captured under Rule 803. Now, this is not exhaustive, as you all know, of all the exceptions to the hearsay rule, but these are going to be usually the most common rules we're relying on for domestic violence prosecutions, with or without the victim participating, or whether or not the victim is available or unavailable to testify. And that's going to be things like excited utterance, existing mental, emotional, or physical condition, statements made for medical treatment or diagnosis, or recorded recollection. So let's take a little bit of a dive into each of those. Excited utterance, it's probably one of the most go-to tools. The components, of course, is that the declarant, or when the statement was made, they had personal knowledge of the exciting or startling event, which is going to be the abuse. That abuse then provoked the statement that is being offered as an excited utterance. And the statement, of course, relates to the exciting or startling event. So the sort of things, especially for intimate partner violence investigations, is to get the foundation for this excited utterance. We hopefully want our reports and our responders to, when they're either interviewing third-party witnesses to talk to the victim, or when they themselves are talking to the victim at that initial response, that they're reporting the specifics of our victim's demeanor, not conclusions, not just the victim was excited or the victim was upset, but what led them to that conclusion. The victim's voice was shaking, there was teary-eyed, the victim was gesticulating, the victim couldn't stay still, the victim seemed stunned and unresponsive to questions, all that. And ideally also is that when they get this disclosure, we can get some sort of temporal connection as to when it happened by asking the next question. Do you know how long ago this happened, what you're telling me about? Oh, it was right before you were called. And most victims, of course, because of trauma and other reasons, they might not have a precise answer. Oh, 12 and a half minutes or an hour ago or 2.5 hours ago. But ideally in that initial response, we're getting a time connection between the disclosure and the excited utterance and when the event happened. So what some jurisdictions call present sense impression, but in Minnesota is then existing mental, emotional, or physical condition. It's different than excited utterance, although of course it can be overlapping and fit both, in that it must be simultaneous to the event, no delay. For example, he's hitting me. For intimate partner investigations, where we're going to find these statements a lot of times, and this is not meant to be exhaustive, we're looking for statements made by the victim to third-party eyewitnesses, especially children that might have been in the residence or household when the abuse occurred. neighbors that could have overheard, other family members that were present, etc. Which is one of the reasons why when responding to domestic violence, we want to get statements and memorialize statements from everyone there at the location or in the vicinity of the location, ideally. Medical treatment or diagnosis. Now, the admissibility or scope of admissibility of these statements, it's a little bit more limited in Minnesota than other jurisdictions, but it's still a good tool in the toolkit to have. And this is statements made in the course of medical treatment are admissible through the medical provider. So statements your victim might make in the course of treatment from your paramedic, from your EMT, from your nurse or physician can be admissible only to the extent of the cause of the injury, not the fault. We can't bring in the identity of the defendant through a medical treatment or diagnosis. And the site for that from your Supreme Court is State versus Robinson from 2006. But even, especially if we're having our evidence-based prosecution, this is still really helpful, because even if we have this statement from our medical provider about how the injury is caused, hopefully we have other evidence that can then link it to the defendant, either third parties that were at the scene, maybe our offender was interviewed and minimized what happened, or put himself at the scene, or is the only person who had access. So in combination with another investigation, this can still be a really good tool to show how the injury was caused. We're just going to need other evidence that's going to be able to link that evidence up to the offender, because we're not going to be able to do it through under Minnesota law through the medical treatment or diagnosis exception.
And John,
could I ask a question?
Yes, please.
What are your thoughts on bringing in the nature of, well, the identity of the person may not be admissible, the specific identity, the fact that it was someone who lived in the home, the relationship may be relevant for purposes of planning for the victim's discharge. I have had some success in bringing in that information. What are your thoughts on that?
This is why most jurisdictions don't follow the Minnesota rule, because they recognize that knowing who the offender is does have medically relevant purposes, and most medical providers can explain it. Like, I need to know who did this so I can develop an appropriate aftercare plan, which is going to be medically relevant. And so, and while we don't advocate policy, that's a rationale adopted by most jurisdictions, and I would agree with that. If it comes in through your medical provider and it simply complements other evidence that already references the identity, then it's probably going to be harmless error. I don't want to predict your courts, but that's what I would argue it is, because it's harmless in the sense it's redundant of other evidence you already had. But I just having had an appellate stint, I don't want to say I become risk adverse, but I become sort of belt and suspenders. So if I was being extra careful, I probably, given the current state of Minnesota law, I probably wouldn't ask my medical provider, well, did the patient tell you who did this? Or why do you ask the patient who did this? At least my understanding of Minnesota law, I probably wouldn't develop that with my medical provider. I'd probably try to do that with other evidence. Now, in light of the statement, if the medical provider is saying, okay, I treated the victim at this time, the victim said, this is where it happened, this is how it happened, this is the injury, this is how they told me they developed, or why I was treating them, or what they wanted me to treat them for. In reality, I think most fact finders are they're not going to have to be Sherlock to make the deduction as to connect it to who. So I would probably be safe and I might even say, now listen, for legal purposes, doctor, I don't want you to tell me anything about this patient told you about who did it, but just tell me what they told you about how these injuries were caused, in reference. And I mean, I think that's appropriate to frame it. And frankly, in terms of advocacy, I think then most jurors will be like, oh, so it's not, the attorney's not asking for a reason not to be clever. So, but that said, you all know the risk, you can all make better risk evaluations than I can in terms of protecting the record, practicing directly in Minnesota courts than some TA provider from outside who just looked over your cases. But I would I would avoid bringing an identity through my medical provider for that reason. Make sense? Mike, did you want to add something to what Tara said? And again, if I misunderstood Minnesota law, please correct me.
So believe it or not, I was going to raise the same issue that Tara did. But John, I'm not sure. I think I was tracking with everything that everybody was saying. But I think that it is, I think maybe not the actual identity, that John Smith hit me, but the fact that my boyfriend with whom I live or something like that is very relevant to the medical diagnosis for reasons I think that were already stated for after, like a discharge orders, because you don't want to be, as a doctor, necessarily releasing someone to a dangerous situation that caused the injury that you're seeing them there for in the first place. So I think that if not the actual identity, certainly the relationship, at least in some cases, could be very relevant for the purposes of making a medical diagnosis. So I'm interested to hear your thoughts about that.
I would recommend, if you are exploring that, or maybe even if you develop a foundation on the record, don't let your medical provider just say, well, the victim told me, the patient told me, the boyfriend. And it's like, well, and make sure you prep with your medical witness ahead of time. Well, why do you ask about the boyfriend? Why do you ask about either who did it? And make sure there's an explanation from the medical provider on the record about why they ask that. And this isn't probably with some medical providers might have a very sort of informed understanding about why they're asking it. I don't think you should go in assuming your medical provider has that informed understanding about why they ask that. Like maybe your only option is going to be that EMT or paramedic. And I don't know, through sort of prioritization of training, they might not be able to articulate that well, especially if it's not an issue that's been discussed beforehand. So I would have these conversations with your medical providers before you get on the stand, that if it comes up, make sure you're putting on the record about why this is asked and why it's so critical for you as a medical provider to develop aftercare issues. And if they can't articulate why they ask that, I would avoid exploring that with my medical provider.
Yeah, thanks. That makes sense.
So, and again, if I'm correct about Minnesota law, then you maybe have a good record to challenge that. But if there's nothing on there, there could be jeopardy. All right, so prior recorded recollection, and again, this is going to be one of the most common exceptions or main tools in the toolkit for cases where the victim's minimizing or recanting. But the foundation components is, of course, witness once knew about the matter. Recorded recollection was made or adopted when matter was fresh, and it accurately reflects a witness's knowledge at the time. And essentially, ideally, this memorialization is going to be on video or audio recording. Worst case scenarios, it can be a written statement, although taking written statements from domestic violence victims isn't very trauma informed. But this is a great tool when the victim testifies and minimizes or recants intimate partner violence. And of course, you use this medium to do so. So I do want to take a quick exploration, especially with our time that's left, into Crawford and the Constitution. And of course, these issues and how they interplay with the hearsay exceptions. It begins with the Sixth Amendment Confrontation Clause, which mirrors what's in the Minnesota Constitution, Article 1, Section 6. And that gives you the right to be confronted with the witnesses against you. As folks might remember from when, again, I was practicing when Crawford came out. I didn't learn about it in a law school class. But Crawford requires a secondary analysis of hearsay statements when the declarant isn't testifying. And that is whether the statements are testimonial. What's a testimonial statement? It's a statement whose primary purpose is for use in later prosecution, rather than just in response to an emergency. What kind of statements are going to be testimonial? Generally, it's more formal statements made to law enforcement or their agents Because more often than not, when a witness or declarant speaks to one of these people, it's in anticipation for a criminal prosecution, and that's a primary purpose for gathering that statement. Non-testimonial statements can be made during an ongoing emergency, like maybe to that initial responding officer before it evolves into investigation, to a 911 caller, casual remarks to others, or for purposes of medical treatment. And again, this Crawford rule is one of the things why, as investigators, we always want to encourage speaking to third-party non-law enforcement witnesses, because then we don't have to trigger any of this Crawford testimonial issue. We can just get into the nitty-gritty of whether or not there's a hearsay exception. So an example of testimonial statements, of course, made to a detective after that initial response, testimony at a pretrial hearing or grand jury or probable cause hearing, deposition testimonies, things like that, testimony or statements made in anticipation or preparation or because of litigation. Some non-testimonial examples could be in response to an ongoing emergency, like a 911 call on the scene to an officer, maybe casual responses or remarks to non-law enforcement officials, or statements to medical professionals, which is the other reason why that medical exception hearsay is such a great tool, because it's going to be avoiding this Crawford analysis. Even if we do have a statement that's testimonial, it can still be admissible if the victim testifies, or if the victim previously testified and the defense had a full and fair cross-examination. So if there's a transcript where the defense had a fair chance for cross-examination, or with what we're going to be exploring next week, if there's a forfeiture by wrongdoing exception that applies. So given the time, I'm going to sort of skip through some of the examples, but essentially when we have an out-of-court statement from our victim, really the three levels of analysis we sort of recommend, or exercises you run through, is with each statement, is it hearsay? If it is hearsay or might be hearsay or could be argued, do you have an exception you can use? And if you do have an exception, then the last analysis is a testimonial. So here's just a quick exercise, which I'm not going to get a participation on. I've lived victim's neighbor. I've lived next to the victim for 6 years. 6 months before this happened, Jess, the victim, knocked on my door late at night. When I opened the door, she was crying and had a bloody nose. Jess told me that Sam had just gone crazy and she needed to stay with me for the night. So from the victim's neighbor, it's probably hearsay. You can probably argue that's excited utterance, probably not close enough for present sense impression. Is the statement testimonial? Well, no, it's just the neighbor saying what happened in response. So that's not testimonial. From a sexual assault nurse examiner, here's an example. I treated Chris at the hospital. I took a medical history, an assault history, conducted a physical exam, and provided discharge instructions. During the assault history, Chris told me that his boyfriend grabbed him by the neck and held him against the wall, making it hard for him to breathe. Well, that is hearsay. Does an exception to hearsay apply? Well, just remember all our conversation about the medical exception hearsay in Minnesota. Certainly is to fault, maybe not as to the boyfriend, although I think there'd be good medical reasons to asking about the boyfriend doing that. And is the statement testimonial? No, it's a sane nurse, and so non-law enforcement. So one of the things we do want to talk about is securing the victim's appearance. This is something we recommend or suggest not doing or avoiding, because again, we talk about coercive methods and the challenges and burdens victims are facing. Using coercive methods, compelling testimony, issuing bench warrants, the things about those is that you really aren't going to be facilitating maybe much cooperative testimony by the victims. And what's really sort of concerning about those practices, especially in the light of the pressures that victims are facing to testify, is that you're probably going to be creating conditions where a victim's going to be more reluctant to report or disclose or call 911 in the future. So that's why we talk about all these methods of an evidence-based prosecution that doesn't rely on the victim's testimony. So we don't have to engage in non-victim centered practices like coercing victims to testify. Some jurisdictions, it can also expose you to losing grant funding. So I do want to, in the time that remains, and we're going to be able to cover everything. I apologize for being a little bit expedited now, but we had some good conversations, so it was certainly worth it. The strategies in this case, especially when we know our victim isn't going to be participating, either unavailable or recanting or minimizing, we don't want to be focusing, we want to keep our focus on the offender, what the offender did, rather than apologizing or explaining for the victim, including these challenges from the victim, offering evidence and argument that relates back to how the offender caused these challenges. So how we can do this, just generally speaking, and of course it's got to be individualized for each case at trial, but develop an offender-focused theme and theory, how they exercise, the offender exercised their power and control, how our offender intimidated and controlled the victim. Take these weaknesses in the case and turn them into strengths. Like if we have a victim who's not participating or minimizing or recanting, and we have a good investigation that can show what the victim disclosed there, we really have a way to sort of highlight this is how isolated and abused and preyed upon our victim is. We want to also be always open to discovering defenses. I bet you defense bar in St. Paul is similar to what I dealt with in Berks County, but all too often defense attorneys were only too happy and willing to tell me what was wrong with my case. That's an opportunity. We should invite defense attorneys to do this because this is a good chance for us to sort of understand and appreciate the arguments that they're going to be developing. While it's not appropriate under constitutional protections to interview the defendant, regardless of whether or not they're representative, when we learn about defense witnesses or potential defense witnesses, we want to make an opportunity to proactively at least attempt to interview them or ask our investigators to do so, find out what they say about the case, see if they can be at least locked into a statement. But even if they tell our investigators, I don't want to talk to you, they've just compromised their credibility if they testify for the defendant, because we can ask them on cross-examination. Isn't it true you didn't want to talk to us about the truth about what happened until you showed up for court? And be working with our partners, both in advocacy and in law enforcement. Jury selection, these are issues we don't want to run from. We want to confront and bring out the challenges and educate our jury about them. Make sure that our jurors understand that, hey, look, elements of our crime, if they can be, that they understand they can be proven even without victim testimony, that's not critical. Make sure that they understand issues about counterintuitive victim behavior, maybe by asking and using panel members who have experience with victims of domestic violence, whether that was ongoing, whether it was reported. Making sure that if the evidence proves the defendant guilty, can they still convict even if the victim doesn't testify, or even if there's a recant or minimization. And of course, making sure that no one holds views such as domestic violence as a private crime or private family matter, or that they don't hold those kinds of personal views. In an opening statement, we want to be careful not to predict our victim's testimony. Recantation or truth can happen at any point. I've seen a lot of defense attorneys burn this when they examined a victim too aggressively or adversarial. It makes our victims angry and sort of turns them back to us. And we want to be in a position with our opening statement where we didn't predict too much what was going to happen. When a victim does testify for the defendant or adversely to us, we don't want to use traditional aggressive examination tactics. Just sort of elicit favorable testimony, maybe about dependency or about on the offender, economic or social network, as well as other opportunities and things the offender might have done to exploit this minimization or recantation. Abusing a victim is never a good idea because it can backfire, and we of course don't want to re-victimize the victim. And like any sort of closing arguments, we want to try to mirror the legal language the judge uses during jury instructions, circle back to the issues we developed during voir dire, highlight offender behavior and how it impacted the victim's ability to participate. A lot of times it can be understandable in light of the circumstances, like if there's circumstances such as Rachel, hopefully we could highlight those to the jury so they can understand, and efforts the offender made to frustrate our ability to prosecute the case can be framed as consciousness of guilt. So there's additional resources from Equitas, especially on Crawford and its progeny. You can find that and download that for free on our website. Going forward, we want to do things to support victims to enhance their ability to participate in trial, thoroughly investigate and document evidence in domestic violence cases, identify and preserve admissible out-of-court statements, and work with our law enforcement partners as to how to identify those during an investigation, and litigate admission of statements pre-trial. So here's my contact information. My apologies, I'm a minute over the allotted time, but thank you for all staying with me. I don't think we've had any attendance drop off. So as you're found in contempt for being late for court, I appreciate the sacrifice you made for me, and I won't be able to help with bail money. But Tara has already indicated to me she will. But thank you all so much.